Payson, step to the counter, state your full name for the judge. Mr. Trent, Lee Green, sir.
All right. All right, and let me confirm you're still residing. The state is alleging one additional charge against you, which is burglary in the third degree. That's a felony allegation that you have the right to remain silent, right to counsel, and right to trial on. I've scheduled you for a preliminary hearing on the 15th of January at 4:00 p.m. The preliminary hearing is to determine if there's probable cause to charge you with that crime. If there is probable cause, then the case will bind over to the Gila County Superior Court. If there's not probable cause, that charge could dismiss. There is a possibility that the case will go in front of a grand jury. If that occurs, you'll be notified, and that may make this court date null and void, but we don't know that as of now, so you're ordered to be in court on that date. Your release conditions are the following: obey all orders of the court, do not commit any crimes, notify the court immediately if your address changes, do not leave the state of Arizona without permission of the court, do not go near the location of the alleged offense, and do not contact the alleged victim, and do not possess any firearms because it's a felony allegation.
Yes, sir.
All right. There's going to be a $1,500 bond placed on you. I know you're held in custody on that probation hold already, but additionally, there's a $1,500 bond. What that does is makes the prosecutor on this charge have to file a formal complaint against you within 48 hours. If they fail to do that, you'll be released on this charge. Because of the lack of the complaint, but they do have up to 7 years or the statute limitations from the date of your arrest of this charge to file that charge. Being that you're held in custody on a felony, you also have a right to a court-appointed attorney if you cannot afford to hire one. I will send a financial questionnaire that if you wish to exercise your right for a court-appointed attorney, just complete that questionnaire, and if that complaint does file in 48 hours, your attorney will be assigned. They'll be made aware of your bond and be in touch with you regarding the charge.
Okay, if they don't file within 48 hours, I'll be released.
Well, you'll be released on this charge. You're still held on the probation hold from the other judge advising you of that. So okay. You'll be held on that until the probation or the Superior Court sees you on that, and then they'll make a determination whether they're going to hold you or not on that.
Okay.
Any other questions in that, sir?
Yeah, I'm trying to go to like a detox or something. I'm doing pretty bad.
Okay. Well, you got up here in front of these, so if you have a medical emergency, just let the staff there know, and then they'll take you to the hospital and bring you back to the jail. So.
I hit my head.
Anything else in that, sir?
Yes, sir.
Okay, that's all?
Thank you.
You bet.
Brother Judge, state your full name. Right here.
Yes, sir. Can you state your full name?
Larry Michael Miller.
All right, Mr. Miller. And then it's on that middle name, is that Michael?
Say it again. Oh, yes. Yes.
The state is alleging two charges against you. Both of them are misdemeanor violations. The first one is DUI. impaired to the slightest degree. And then the second charge is an open container of liquor in the vehicle, unauthorized. On those charges, you have the right to remain silent, right to counsel, and right to trial. I've scheduled you for an arraignment on the 28th of January at 9:00 a.m. The arraignment is where you'll need to be prepared to plead either guilty, not guilty, or no contest on that date. Depending on how you plead will be what happens next with the court proceeding. All of those options, as well as the penalty range for each of those charges, will be explained to you prior to you giving your plea on that date, so you'll be well informed before you give your plea on record. Your release conditions are as follows: obey all orders of the court, do not commit any crimes, notify the court immediately of any address change, do not leave the state of Arizona without permission of the court. Do you understand those release conditions?
Yes.
Can you
Yes, sir.
can you abide by those?
Yes, sir.
And will you show up in court as ordered?
I will.
Okay, we'll release you on your own recognizance. Do you have any questions?
Not this time, no.
Okay, we'll see you on that date, then you'll get a copy and be released shortly.
Okay.
Yeah, he'll send it over. He was heavy send right here, and he wants to get another guy. So get the next one, Judge.
Okay, thank you.
Yeah. Oh, he's already coming back. Were you on this side?
Yeah.
Okay.
So from the counter, they sworn into the judge, cause you know. Okay.
Can you state your name, please?
Lauren Dixon.
Sworn.
Lauren Dixon.
Okay, sir, do you have a middle name at all?
No.
Okay.
Sorry.
All right, Mr. Dixon. The state is alleging one charge against you, and that is a charge of driving with a suspended, revoked, or canceled driver's license, a misdemeanor violation. What I'd like to do is, with your permission, is go ahead and, can I get a ring? Go ahead and arraign you on that charge. That'll save you a trip coming back up to Payson to have that arraignment. So I'll explain the penalty range, explain the maximum penalty, but I need your permission to waive your personal appearance to come back in court. So you would agree to do this by video. Do I have your consent for that?
Yes.
Okay. All right, sir. So the driving suspended, revoked, or canceled is a class 1 misdemeanor. The maximum penalty on it is $2,500, 6 months of jail, and or 3 years of probation. There is no jail time being sought. So whether you plead guilty or no contest today, or whether you're found guilty after a trial, you're not facing any jail time as a consequence of this charge. Do you understand that? Okay. Your options are to plead guilty, not guilty, or no contest. The difference between a guilty plea and a no contest plea is the following. If you plead guilty, you're admitting to the crime and that you committed the crime. If you plead no contest, you're not admitting or denying the facts of the case, but you're accepting the conviction. Both guilty and no contest show on a criminal history as a conviction. You understand that? All right. The other option is to plead not guilty. If you plead not guilty, I'll schedule you back to court for what's called a pre-trial conference. That's where you'll meet with the prosecutor on the case, discuss the case, and one of three results will occur after that meeting. Number one, the case will in fact proceed to a trial. Number two, the case could enter a plea agreement. Or number three, the case could dismiss. Do you understand that? All right. You also have the right to an attorney. Since this case does not have any jail time assigned to it, you don't have the right to a court-appointed attorney unless you can give a good cause for that. Now, not being able to afford an attorney is one, but it's two-part. Like if there was jail time, that would qualify. If you have a mental disability and you don't understand the process, that would be a second. So unless you give one of those reasons, you'd have to either waive the presence of an attorney, hire an attorney at your own expense, or give me a qualifying reason. Do you understand that, sir?
Yes.
Okay. Regarding the decision with the attorney, do you wish to waive the presence of an attorney, hire an attorney at your own expense?
Yes, waive it.
Okay. So I'll send. Okay. So I'll.
No contest on that too, please.
All right. We're just about there, sir. So I'm going to send you a form that is the waiver of the personal appearance that I earlier spoke to you about, and waiving of the presence of an attorney. So you'll just have to sign that form. All right. So you decided that you wish to enter a plea of no contest, correct?
Yes. Yes.
All right, sir. We'll be able to move forward into sentencing, but before I do that, I'd like to make you aware of the rights that you're giving up by entering a no contest plea, okay? By entering a no contest plea, you're giving up the following rights. You're giving up the right to plead not guilty and require the state to prove your guilt beyond a reasonable doubt. You're giving up the right to have a trial in front of a judge. You're giving up the right to have the assistance of an attorney at all stages of the proceeding, including an appeal, and that's what we talked about, the attorney waiver form. You're giving up the right to confront witnesses against you and cross-examine them as to the truthfulness of their testimony. You're giving up the right to present your own evidence on your own behalf and have the court compel your chosen witnesses to appear and testify free of charge. You're giving up the right to remain silent and to be presumed innocent until proven guilty beyond a reasonable doubt, and also giving up the right to a direct appeal. Are you on probation or parole, sir?
No.
Okay. I want to make you aware of possible collateral consequences. Is a key word there, of possible. It's a general advisory. That is the possible suspension of your driver's license, an impact on a commercial driver's license or other professional license, an impact on insurance rates, the revocation of probation or parole, an increased penalty for further criminal charges, becoming a prohibited possessor if convicted of domestic violence charges, and if you're not a citizen of the United States, a plea or finding of guilt may result in deportation or being denied citizenship or re-entry. Further on your citizenship, it indicates that if you're not a citizen of the United States, pleading guilty or no contest to a crime may affect your immigration status. Admitting guilt may result in deportation even if the charge is later dismissed. Your plea or admission of guilt could result in your deportation or removal, could prevent you from ever being able to get legal status in the United States, or could prevent you from becoming a United States citizen. Understanding each of these rights that I've explained to you, you wish to give those rights up and enter your no contest plea?
Yes.
Okay. You may file a Rule 33 petition for post-conviction relief, and if denied, file a petition for review. I'll give you a letter that explains what that is. It'll also explain to you how to set aside the judgment of conviction pursuant to Arizona Revised Statutes 13905 once all the terms of the sentence have been completed, and you may qualify for a certificate of second chance and apply to seal the records pursuant to Arizona Revised Statutes 13911 once the terms of the sentence and the timeframes therein have been satisfied. So that letter will include each of those bits of information for you to explain that to you. All right, so I want to present a factual basis to you regarding the case that you're not admitting or denying. Since you pled no contest, you're not admitting or denying, but acknowledging that these facts would be used if it went to trial. On 1/4/2026 at about 6:30 p.m., you were contacted at or near the 1200 block of South Beeline Highway, which is milepost 251 on State Route 87 in Payson city limits in Gila County in the jurisdiction of this court. That police contact came from the Payson Police Department. It was discovered that you were operating a motor vehicle on a public roadway while your license was suspended, revoked, or canceled, and you were additionally displaying license plates that were suspended for financial responsibility. You're not admitting or denying those facts. Does that sound consistent as far as the facts that would be presented at court?
Yes.
All right. Sir, the count B violation that I haven't discussed you with, that's a civil traffic violation. That's displaying the license plate that has been suspended because of the lack of insurance at certain point. It could have elapsed at one point. You're not cited for not having insurance, but you're cited for it lapsing and the registration becoming suspended. That takes a responsible or not responsible plea. Do you understand that? If you plead responsible, I'll impose it on the sentencing today. If you plead not responsible, I'll schedule you for civil traffic hearing at a later date. How do you wish to plead to the count B violation?
Not responsible.
Not responsible?
Not responsible.
Okay, I'll enter not responsible on that. All right, sir. All right, regarding your plea of no contest on the criminal charge, are you making that plea voluntarily?
Yes, I am.
Nobody forced, threatened, or harassed you to make that plea?
No.
Did anybody promise you any lighter sentence or punishment that if you pled that you'd receive it?
No.
Okay. Court finds that you entered your plea of no contest knowingly, voluntarily, and intelligently will accept your plea. You'll be receiving a paper that has my initials going down the side column of the paper. That's where I've indicated the rights that I read to you, that you waived one at a time. It'll require your signature at the bottom. The detention staff will help you show you where that form, where to sign that form. Do you wish to give any statement regarding the case before I impose sentencing?
No.
Okay. In one moment, I'll get caught up here. All right, sir, the standard fine for a driving suspended, revoked, or canceled violation is $482. I'm going to give you 30 days to get a driver's license. If you're able to do that and present that evidence of a driver's license to the court, I'll reduce that down to $202. There's a one-time jail fee of $69. That brings the total balance to $551. Are you able to pay that today?
No. I get paid till Friday. On Fridays.
All right, sir, I'll put you on a payment plan. How much can you afford per month?
I can do the minimum $50.
$50?
I can pay it by Friday. I can pay the whole time on Friday.
Is that what you wish to do, is pay the whole balance on Friday? Or do you
Yes.
want to go on a payment plan?
You know what? I'll go with a payment plan. Let's make $100 a month.
$100 a month?
Yeah.
You want me to have your first payment on Friday?
Yes.
Friday the 9th?
Yes.
Okay. right, there's a, per statute, I have to add a one-time payment plan fee if it can't be paid at the time of sentencing. So the total balance was $571, and you're ordered to pay $100 on the 9th of January, and then every 30 days after that on a payment plan. So you'll have that form to sign. That's called the judgment and sentencing form for that. We'll also send you a court date for that civil traffic hearing for that other violation, so you can be ready to present during that hearing as well. Do you have any questions for me at all, sir?
No.
Okay, I'm releasing you on your own recognizance. All this paperwork will be sent over shortly.
Sheriff Ann. Let me ask you.
Hi there, can you state your name, please?
Lolita Dixon.
Thank you.